Last week you read roughly the first half of the Rehnquist book, and that sketched a lot of the early history of the court and the judiciary. And we talked about how the first era of the nation's development, essentially from about 1800 to the Civil War, was dominated by just two Chief Justices, John Marshall and then Roger Taney. And we talked about how the issue of slavery had to be dealt with through a horrific bloody conflict, and then following the war were a number of amendments to the Constitution to finally eliminate slavery from the document and from our body politic. We then moved on to talk about how the court was involved in issues surrounding industrialization and national and commercial expansion in the latter decades of the 19th century. And then it was involved in the first part of the 20th century in the regulation of the workplace and corporate governance. And then we focused on Franklin Roosevelt, who was elected in 1932 in the midst of the Great Depression, and how he was initially thwarted by the court in his attempt to use the federal government to create jobs and improve the U.S. economy. And we saw there that there were quite a number of New Deal measures designed to turn the economy around that were ruled unconstitutional by the court. And this particular slide mentions an act involving debt relief, another one involving membership of on the Federal Trade Commission by presidential appointees, and the third involving the regulation of commerce. So all of this opposition by the court led Roosevelt eventually to propose a plan to expand the number of justices so he could appoint a majority of judges who would allow his own legislative initiatives to stand. And as we read, his so-called court packing scheme ultimately failed in Congress, although this controversy as the controversy was actually underway, the court began moving in FDR's own direction. And by the time he ended his long tenure in office, he'd actually been able to appoint 8 of the 9 justices of the Supreme Court and move the entire institution into his favor. Now, one of the more valuable chapters, to my mind, in the Rehnquist book is the one about the so-called Steel Seizure case, which involved President Harry Truman and the Korean War. And needless to say, most Americans don't know very much about either the Steel Seizure case or the Korean War. At the end of World War II in 1945, the Soviet Union controlled the northern part of the Korean Peninsula, and the United States and its troops controlled the southern part. So the country was really more or less partitioned between the North and the South by the latter part of the war. Now, by 1950, just a few years later, most of the U.S. troops had been pulled out of South Korea, and the large communist regimes in Asia, specifically the Soviet Union and China, didn't think that the U.S. or any of the other Western nations would protect this area if it were attacked. So in 1950, the North Korean army invaded the South. But as it turned out, both the U.S. and the United Nations ended up coming to the defense of the South. And this was mostly under the generalship of Douglas MacArthur. Now, after some initial back and forth, it looked like the U.S. would end up expunging North Korean troops completely out of the country. But at that point, China sent 300,000 of her own troops in to protect the North from occupation by the U.S. and the UN. And so the U.S. was ultimately just driven back toward the middle of the peninsula. And by 1951, the war had really kind of bogged down around the line that separated the North and the South. And by 1952, a possible strike by steel workers in the U.S. Would have crippled production of the tanks and ships and helicopters and the other equipment that the U.S. Army needed to fight the ground war there in Korea. So Harry Truman moved by executive authority as president to take over the steel companies. It was illegal for the unions to strike against the government at the time, so if the government controlled the companies, then there wouldn't have to be a strike. In any case, Rehnquist's chapter on this very nicely describes the politics of this particular case. How the companies filed suit to stop the takeover, how the case was very quickly moved to the Supreme Court just a few months later, how the government lawyers kind of bungled the public relations part of the case, and how ultimately the court ruled against the president, saying that in this case the president simply didn't have the authority under the Constitution to take over an industrial sector of the economy. So what this case really reveals, and Rehnquist stresses this point, is how politics is intimately involved in the court's operations. What we see here is that the court, which was made up entirely of FDR and Truman appointees, so you'd think that they'd support the president in his policy maneuver here. And the court had for 15 years been moving to support executive authority over legislative authority. But as it turned out, the court ruled against the president. And this decision was really influenced by quite a number of factors. Just for example, public opinion had moved sharply against the war and against Truman for pursuing this war. The administration's initial argument that the president was not limited by the Constitution, that really troubled a lot of Americans. And the Truman administration itself was faring pretty poorly in terms of public opinion. And this presumably gave the court the imprimatur it needed to vote against the president. Now, the final era of the court discussed by Rehnquist is the Warren Court era, and this was the period in the 1950s and 60s under Chief Justice Earl Warren, who had, by the way, previously been Republican governor of California. And during this period, the court really moved toward providing much greater civil and personal rights to individuals and members of minority groups. The first big famous case under Earl Warren involved school desegregation. You remember last time we talked about the 1896 Plessy decision, which allowed separate but equal facilities and institutions for whites and blacks. Now, this ruling ultimately led to a whole system of Jim Crow laws in southern states and segregative practices in the North. The civil rights movement really got launched in the 1940s as a reaction against black soldiers being placed into segregated units in World War II, and then not really receiving the same kind of preferential treatment that white veterans received when they were decommissioned and returned to civilian life after the war. Now, by the 1950s, the best attempt to assault the legal underpinnings of segregation involved public schooling, where it was really quite clear that the schools for blacks in most states were inferior to those provided for white kids. And the Brown case in Kansas was really several school segregation lawsuits rolled into one. And Earl Warren, very, very early in his term, managed to get unanimous vote on the part of the court against having segregated schools. And of course, this decision launched the country in the direction of righting a whole host of historic wrongs. Now, even though the Warren Court is routinely lambasted by conservatives for, representing kind of liberalism run amok, it really did lay the groundwork for much of our current system of jurisprudence and politics. So, for example, in 1962, we had the Carr decision, which requires local, state, and federal elective officials to represent roughly similar numbers of voters, and this is the so-called one man, one vote ruling. And this really helped overturn lots of situations where you had small numbers of rural voters routinely thwarting the wishes of much larger numbers of urban voters, where there was just maldistribution of voters for representatives. And we have a number of rulings that extended the federal civil rights acts of the post-Civil War period to the states. There were rulings under the Warren era that involved the rights of criminals and the ground rules for the police in gathering evidence, the Miranda ruling, for example. And we take a lot of these rights for granted today in our modern political era. Now, the Warren era was followed by the court under Chief Justice Warren Burger. And the Burger Court really followed the drift of the Warren Court, although it did qualify a few of some of the earlier courts' perceived excesses. And a couple of the noteworthy cases here involved the Griggs case from 1971, which ruled that any employment test given by a company or an organization really had to be demonstrably related to the required job skills in question. And another was the 1973 Roe v. Wade decision, which legalized abortion in the first trimester. And obviously that ruling has been subject to lots of modifications and political debate, but it has nevertheless endured over about the last 4 decades. Now, since Burger retired and was replaced by William Rehnquist himself, the author of our book, and then more recently John Roberts, we have had a generally more conservative Supreme Court, but I would say it really hasn't radically altered the public policy framework that was put in place under Franklin Roosevelt, Earl Warren, and Warren Burger. And generally, what more conservative justices have done is allowed states more leeway in pursuing criminal cases and regulating things like abortion, but has not reined in federal powers very much. And I'll talk a little bit more about some of these changes in the next segment.